for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Look, we like to follow sports here too, and sports law and issues in the legal community when it comes to the NFL, NBA, et cetera, et cetera. Antonio Brown, everybody knows who listens to any sports. He's a wide receiver for the Raiders, former wide receiver for the Steelers, has got a little checkered past, as in not as a bad, but as in a little bit, let me say edgy or gets in trouble or has little spats.
A diva. He's a diva.
That's a very good way to put it.
All right, so Cal calls him the diva. All right, diva, that's a good collaboration. So what has happened? Give us the overview, Todd. I can give it, but once you give it, since you found the latest that just popped up a few hours ago.
Sure. Antonio Brown signed with the Raiders in the offseason for $50 million. It comes out to about $215,000 a game based upon his contract. And he had a tumultuous time with the Raiders even before training camp began. He had frostbite on his feet because of cryotherapy that he got during the offseason. Then the league banned the helmet that he uses, so he couldn't play because he didn't have the right kind of helmet. And then he got into it with the Raiders. And when we come back, we're going to finish off the timeline and talk about what just came down in the last 30 minutes.
It's really interesting. We'll be right back.
Radio Law Talk. Now, back to the show.
So talking again about Antonio Brown, so continue on with that.
Thank you, Fred. So Antonio Brown had these issues with his feet and with his helmet, and it caused him to miss time during training camp. He had legal battles with the NFL because the NFL came in and actually banned certain type of helmets that were too old because they were not concussion protection worthy, and he didn't like that. Well, last week, the Raiders GM, Mike Mayock, sent Brown a notice that they were fining him in excess of $56,000 for the time that he missed during training camp. Well, that got Brown really upset, and he and Mayock had a heated in-person altercation. Some reports say that Brown had to be held back and threatened to hit Mayock and stuff. The long and short of it is Brown was suspended for Oakland's first game coming up, I believe it's Monday night. After that happened, the coach, John Gruden, intervened and was able to play peacemaker and made an announcement yesterday that, yes, Brown would indeed play in the upcoming game, after which Antonio Brown posted a video that looked like it had been professionally made, but posted a video on Instagram that, among other things, included the conversation, a recording of his phone call with Coach Gruden. And it didn't appear to be with Gruden's consent. And after that, yesterday, the Raiders proposed to fine Brown $215,000 for conduct detrimental to the team. They removed the guarantees of his contract, his $50 million contract. And this morning, Antonio Brown said, "Release me," and the Raiders did.
Ooh.
Wow.
What? They released him? They just did that?
They just released
before
him
the
this
first
morning.
game.
And that's significant because they removed the guarantees, and by releasing him before the first game, they owe him nothing on the $50 million contract.
In fact, it has cost him money because he has the fines, right?
Yep.
He has all these other liabilities, training at his own expense, because he doesn't get paid until the first game check. He just gets a weekly, but he didn't show up for any of the preseason workouts, so he got nothing out of it.
And my guess is he won't be liable for the $56,000 fine or the $215,000 conduct detrimental because they released him. He's gone.
Right.
So he probably won't have to pay that. But everything else he talked about, yeah, he's on the hook for that.
You know what's interesting is, believe it or not, everyone thinks, oh, they're in training camp. They get paid. They get paid a very small stipend.
Like $1,000 a week or something.
Yeah, it's like $3,500 for the month or something like that.
Yeah.
It's not much. Right. And where they make their big bucks, like you say, is the first week. Bam, they get paid weekly.
Game check.
Last year, there was a guy that was a fringe player. He probably wasn't going to make. He's one of these undrafted rookie free agents, a defensive player. His best chance was to make it on the practice squad for some team. Now, they make $8,000 a week minimum, but still, he hadn't been paid a dime. He leveled a high hit during training camp, was fined by the league $25,000 for the high hit. He had not received a dime for playing yet. He was in the hole 25,000.
And so why are we bringing all this up about Antonio Brown? We're segueing this into an issue of recording and
That's
the
right.
laws behind recording someone. So he records Gruden without supposedly his permission and posts it. Is that legal or not? The answer is it depends what state, but definitely in California, no, it's not legal.
That's right. California is what's known as a two-party consent state, which means that if, let's just limit it to a telephone conversation because that's what this was. If you are going to record a telephone conversation, according to Penal Code Section 632, which, by the way, the violation is either a misdemeanor or a felony, it's a wobbler. And if you make that recording, you have to have your consent, obviously, but the consent of the person you're talking to or the one that you're recording.
Right.
Some states are single-party consent.
Right, Utah.
Yes.
One caveat. If you record that conversation, half of the conversation that you can hear in a public place, then that rule does not apply. Your expectation of privacy when you're having a conversation in a public place is no longer in place. And, of course, it's determined. It's case by case. But that is kind of an important factor.
That's why he's a producer acting like a lawyer.
That's
Well,
right.
and-
I'm a former TV news guy. Believe me, I've lived this stuff.
And you talked about a term called expectation of privacy. I just
Right.
want to really quickly talk about that. So let's say I'm recording Denise, okay? Obviously, I have my consent because I got the recorder. If it's in a situation where Denise reasonably thinks that this conversation is between the two of us and should be kept private between the two of us, that's what Cal's talking about. That's her expectation of privacy in the conversation. However, if we're in the middle, let's say we are standing at a restaurant waiting to be seated and there's people all around us and we're talking and anybody can hear, her expectation that that conversation would be private is much lower because it's in a situation where anybody can hear it. So the more a person thinks that a conversation would be kept private, the greater the need for consent on that person's behalf, with a few other exceptions that I bet Denise can talk about.
Right. I had a domestic violence case, and this is no joke. Inside the home, the family members were talking about killing my client, and she recorded this, and she had like 2-3 hours of recordings, and that all of those recordings came in. The judge found that there was an expectation of privacy. However, because she recorded crimes, that was an exception to this two-party consent.
Interesting to know
Yeah.
that.
Another exception is if a person has a restraining order, a no-contact restraining order against, like let's say Fred's got a no-contact restraining order against me. Fred can surreptitiously record communication if I call him as evidence that I'm violating that restraining order. That can occur.
Now,
Yeah, and that's usually in the court order
Yes.
itself, and that can be a criminal protective order, that could be a civil harassment protective order, or that can be a domestic violence protective order.
855 Law Radio, or tweet us at Radio Law Talk if you want to talk about this. But another point about this, and this is what I'm not clear on, to be honest with you. What if someone calls you from another state, in a state that's you have to have both party consent, but they're calling from a state that is a one party consent? I would assume it applies because you're in the state that's the two party consent. But let me finish my point.
Yeah.
My point is, I knew of an individual that I knew that state was a single party state. And every time that individual, which is very rare, would call me, guess what I would say? First thing, I would say, are you recording me? If you are, you do not have permission to record me. And then what would happen also is, you be careful what you say, but then I would, within about 5 minutes, are you recording me? And he'd say, no. Good. You do not have my permission. I would break it up every once in a while and say that. So, because even though calling out of a state into a state, I'm in the state that's the two-party permission, but you never know. So that's what I did.
So I think if you were going to use the recording in California, then your not consent would be upheld. If you're going to use the state, like say New York, where it's a one-party state, then you only need the consent of one party.
Well, and we've got two issues there. For example, under the same penal code section in California, 632, subdivision D of that says any recording made in violation of this subdivision is inadmissible in any judicial administrative court proceeding in California. So Denise is correct.
Right.
The other question that goes to what Fred had kind of reminds me of our astronaut case that we talked about last week, which is, where is the jurisdiction if you want to prosecute this crime? Now, in that case there, where a person maybe stole the identity, but she's up circling the globe, jurisdiction is established where the victim resides. So if the victim was in New York law would be followed because that's where the victim's identity was stolen. That's where she's at. I would assume, now I don't have this 100%, but I would think that if the victim is located in California, there may be liability from California law because that's where the recording arguably took place. It's where the victim was.
What if the victim were in space? What if the roles were reversed? Now, that's an interesting question, isn't it?
Yeah. Well, I mean, I think we have to talk to the alien judges and see what they say.
Yes.
But that's interesting. That's why we bring that up with the Antonio Brown, because Oakland is obviously in California.
Yep.
And this is where the recording occurred when he talked to Gruden. And it's going to be interesting to see what happens with the Oakland Raiders game. I think that's going to be fun to watch. And by the way, there's so much swirling around Oakland Raiders. And we talked about lawsuits before about the where they're going to play football.
Yep.
Now you got the new stadium, by the way, is beautiful in Las Vegas. And but anyway,
We should go there.
We should go.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.